Good afternoon. Now that it is 12 o'clock, we're going to go ahead and get started with today's webinar. My name is Matt Erlanger, and the name of the presentation is So Your Project Was Canceled, Now What? And we're going to go over some of the rights to payment generally that contractors and subcontractors have, and more specifically in the context of what happens when the project gets canceled. Just logistically, everybody is on mute. You can submit questions via the question and answer box, and the presentation is being recorded and it will be distributed after the webinar. Now, as I said, my name is Matt Erlanger. I'm an associate at Cohen Seglius, Palace Greenhall and Furman. I've been with the firm for about 9 years, focusing exclusively in construction litigation, representing contractors, subcontractors, suppliers, primarily Pennsylvania and New Jersey, but throughout the country as well. For those of you who don't know about our firm, Cohen Seglius has more than 80 attorneys across 8 offices. I'm out of the Philadelphia office, which is our largest office, but there are other offices that you see listed there. We're one of the largest construction law firms in the country. We represent over 1,200 contractors, construction-related companies across the country, and our attorneys and construction practice groups are frequently recognized nationally as well as regionally. So what topics are we going to cover today? First, what happens when a private owner cancels a project on which you have a contract? Then we're going to change that up a little bit, and what happens if it's a public owner that cancels the project? And then more specifically, what if you're contracted to just supply materials instead of labor? And lastly, even more specifically, specially fabricated materials. What happens if you are contracted to supply specially fabricated materials and your project gets canceled? So let's take a look at cancellation of private projects in Pennsylvania. Hypothetical 1, which is sort of what I just went through. ABC Contracting LLC was hired as a subcontractor to Big Bucks. That's the general contractor to provide on-site labor on the construction of a new office building. ABC has begun performance. The project's progressing. Big Bucks says, hey, price escalations, the owner's running out of money, they're canceling the project. So what are your rights there? How do you get paid? Pennsylvania, you have mechanics lien rights, possibly a payment bond, and then your standard contract remedies, breach of contract, violation of the Contractor Subcontractor Payment Act, and then potentially some other quasi-contract remedies, unjust enrichment, quantum meruit, and causes of action that are similar to those. New Jersey is somewhat similar. You have construction lien rights, payment bond potentially, and then your contract remedies, breach of contract, and the Prompt Payment Act. So what's a mechanics lien? It's a statutory created lien for the purpose of securing priority for payment for work performed or materials provided in erecting or repairing a building. It creates a security interest against the real property where the work's performed, and a lien interferes with the owner's ability to sell the property or to borrow money. As a result, this puts a significant amount of pressure on owners to ensure that contractors get paid timely. And because it's a statutory remedy that ties up the owner's property, there's a requirement that you strictly comply with the requirements of the statute. Otherwise, your lien may be void and invalid. So lien law in Pennsylvania generally states that every improvement shall be subject to a lien for the payment of all debts by the owner to the contractor or contractor to any of its subcontractors for labor or material furnished in the erection or construction or alteration or repair of the improvement, provided that the amount of the claim is in excess of $500. So how does this apply when the when the improvement's not completed? Section 1305 says, except in case of destruction by fire or other casualty, where through no fault of the claimant, the improvement's not completed, the right to lien shall nevertheless exist. So if unless the project's destroyed by fire or other casualty, if it's not the claimant's fault that the work's not completed, they don't lose your lien rights. And courts have interpreted that where the contractor is unable to complete its work due to the actions of either the owner or the general contractor. If you're a subcontractor, you still have your lien rights. For instance, the owner runs out of money and decides not to finish the project. Your lien rights remain. If the general contractor files for bankruptcy and the sub and the owner can't come to terms on a completion contract, you still have your lien rights. But if the contractor is primarily responsible for its failure to complete its work, you lose your lien rights. If you are responsible for your inability to complete your work, for instance, if there's a dispute regarding payment and you decide, you know what, I'm not working for free, I'm going to walk off the project, and you don't complete. You might be entitled to do that under the terms of your contract, but you're not entitled to lien in that scenario. So it's something to consider if you're owed payment, whether it makes sense to walk off the project, you may forfeit your lien rights. So who can file a mechanics lien in Pennsylvania? Contractors, contractors contracting directly with the owner. Those are your prime contractors, general contractors, subcontractors, first tier and second tier, and architects and engineers. If in addition to serving as architect and engineer, they have some supervisory responsibility on the project. And what type of work is eligible for a mechanics lien in Pennsylvania? Construction of a new improvement, that's new construction, an addition to an existing improvement, adaptation of an existing improvement, essentially a fit out, altering an existing improvement, and certain incidental activities such as demolition, removal, excavation, and paving. Now, those incidental activities have to be incidental to the improvement. So, for instance, if you have preparatory work, such as you're hired to level a site and the improvement never happens, well, that wouldn't be incidental at that point. If it's a standalone incidental activity, chances are you don't have lien rights. For instance, if all you've done is prepare shop drawings, there's no lien rights because it's not labor or materials for the improvement of the properties, preparatory work. And here's some of the holdings in Pennsylvania: routine landscaping, not lienable; installation of a tennis court in and of itself, not lienable; leveling a lot for storage of materials, not lienable; and the preparation of shop drawings. Now, if those activities are attached to a larger construction project and you perform other work, you would be able to lien. But in that instance, they'd be incidental and not standalone. So if you have lien rights, how do you go about enforcing them? For projects that are over $1.5 million, there's an ability of an owner to register the project by filing a notice of commencement with the Department of General Services, and there's an online directory. If you're working on a searchable project that's registered and you're a subcontractor, you have to provide a notice of furnishing in the directory within 45 days of starting your work. And how do you know if it's registered? Well, there needs to be a conspicuously posted notice on the project site, and it has to be made part of the contract documents, which is provided to all the subcontractors. If you don't provide that notice of commencement on a registered project, you don't have lien rights. So it's very important that on all projects that are over $1.5 million to make sure that you know one way or the other whether it's registered or not. If registered, you have to go through this additional step of providing a notice of commencement, which the form of which is provided in the lien law. Regardless of whether your project's registered or not, you have to file a lien within 6 months of your last day of labor or the last delivery of materials to the project site. And if you're a subcontractor, you have to file a notice, or not file, you have to provide a notice of intent to file a lien to the owner at least 30 days prior to actually filing the lien. So you want to be sure to track your last date of work and the 6 months from that last day of work. And if you're a subcontractor, 30 days prior to that 6 months from your last date of work. And the reason why, if you're a subcontractor, you have to provide the notice of intent to lien is to give the owner an opportunity to address the non-payment prior to the lien actually being filed. And that notice has to be sent either by first-class registered or certified mail, or in the same manner in which you would serve a complaint in Pennsylvania, which is generally by sheriff if you're not in Philadelphia County, or if you are in Philadelphia County, by process server. But if none of these means of actually getting the notice of intent to the owner is available, you can also go through and post the notice of intent to lien conspicuously on the project site. That's generally your last resort there. But you want to be sure to get that notice of intent to file a lien in. Otherwise, you're not able to file a lien as a subcontractor. Once you've gone through that exercise, to actually file the lien, you file it in the Court of Common Pleas in the county where your project's located, and there's certain requirements of items that need to be contained within the lien. Most of these are fairly straightforward and will be known by the lawyer who prepares the lien, but generally the claimant's name and filing status, whether you're a contractor, subcontractor, or subcontractor, the owner's name and address, the date of completion of the work, the lien amount, and description of the property and improvements subject to the lien. And then there's certain additional requirements if the claimant is a contractor with a fixed price contract. You need to include description of the contract, the date of the contract, reference number for the contract, and a general description of the type and character of the lienable work. And if it's not a fixed price contract, you need a detailed statement of the type and character of the lienable work, including itemization. So now you go ahead and you file your lien. What do you do next? Well, you have to serve the notice of filing on the owner within 1 month. Very important. And that has to be served either by the sheriff in any county except for Philadelphia. And if you're in Philadelphia, it can be by a competent adult, typically a process server. Quite often, the owner is located at a property other than the property you're liening. So you want to be sure to know that information and know how you're going to go about getting the notice of filing served within 1 month. If they're out of state, they can be served by a process server or mail. You can also post the property if you're not able to personally serve. Once it is served, the notice of filing, you have to file an affidavit of service or an acceptance of service within 20 days after service. The failure to either timely serve or file an affidavit or acceptance of service will render the lien invalid. And there was a recent Pennsylvania Supreme Court case that said this defense can be raised at any time. So it's very important to strictly adhere to these requirements. Notice of filing within 30 days, and then the affidavit or acceptance of service 20 days after. And once you file your lien, that's not the judgment. You have to file an enforcement action. You file a complaint, and that gets filed with the prothonotary, and they're under the same docket number that you file your lien. The complaint has to be filed within 2 years from the filing of the lien. This can be extended in writing by the owner. This is different from the lien itself. The filing of the lien has to be done within 6 months. That can't be extended, but the filing of the complaint can be must be served same manner as the lien, except it can't be posted. But the failure to timely serve does not serve to invalidate the lien. And finally, you must obtain judgment on the lien within 5 years from the date of filing. This typically isn't an issue, at least not in the general Philadelphia area where the courts tend to move somewhat quickly. But in some of the smaller counties in Pennsylvania, that don't move so fast. Defendants sometimes will try to run out the clock and prevent judgment from being obtained within 5 years. So it's important to keep track of that date as well, and move the case ahead so that you get your judgment within 5 years of filing. So that covers basics of mechanics liens in Pennsylvania. And we do have a question in the box, confirmation of lien right protection procedure when working for a tenant on a landlord property, get landlord written authorization. That's a good point. If you're under contract with the tenant, or you can lien the leasehold interest, you cannot lease the fee simple, the owner's interest in the property, unless there's something in writing that makes clear that the improvement is being provided for the owner's immediate use and benefit. A lot of times it's not known. Sometimes it's apparent from the lease between the landlord and the tenant. If the owner is responsible for paying for some of the improvements, for approving some of the plans and drawings, and getting permits, an argument is better made. But most times you don't know that information when you're filing your lien. So it makes sense to file against both the landlord and the tenant's interest. But unless you can make that showing that the landlord, the improvements are for the landlord's immediate use and benefit, chances are you're probably not going to have lien rights against the owner's interest in the property. So that covers liens. The next topic within private construction in Pennsylvania is payment bonds. And on private projects, there's no requirement that a payment bond be provided. Sometimes an owner will require the general contractor to provide a payment bond. And I think everyone knows what a payment bond is, but it's a three-party agreement. The surety agrees to pay the claimant if its principal fails to make payment to the claimant. So if you're a general contractor and you have to get a payment bond, the payment bond is for the benefit of those subs that you have an obligation to make payment to. An owner will sometimes require this to avoid liens being filed on their property, because when a payment bond is provided, a waiver of mechanics lien rights is permissible. There's a question we'll be addressing New Jersey as well. Yep, we're going to get to New Jersey following Pennsylvania. So a payment bonds provided, a waiver of mechanics lien rights is permissible. A written contract between the owner and the contractor, providing that no mechanics lien shall be filed by anyone, is binding. This typically gets filed, or this has to get filed with the court, and it has to be in effect at the time the subcontracts are entered into. If there's no payment bond, mechanics lien waivers are only permissible either on residential construction projects, or what we more commonly see on non-residential projects in connection with pay applications, and those are only enforceable to the extent of payment and only if the payment is actually received. So what are the subcontractor's rights under the payment bond on a private project? Well, you really have to look to the language of the bond. That's what will control. Bonds are interpreted like contracts, so the plain language is what courts will look to. Some bonds allow first and second tier subs to make claims. Others may extend further to suppliers to second tier subs. Bonds will typically have notice requirements. If you're a lower tier sub, you might have to provide notice of non-payment to the general contractor, so that similar to the lien scenario, so that the general contractor can make sure that you get paid so that there's not a claim on their bond. Some bonds might even allow claimants to recover their attorney's fees. So it really is important to look to the language of the bond to see what your rights are and what you can get paid for. There's no bond, no lien rights. Your you're relegated to your contractual remedies. If there is a bond or lien rights, you still have your contractual remedies, but that's in addition to those rights. And one of the main statutes in Pennsylvania for the to ensure payment is CASPA. That's the Contractor Subcontractor Payment Act. It sets forth the timing requirements for payment on private construction projects. Although this can be expressly modified by the parties, the default is the owner has to pay the prime contractor within 20 days after the end of the billing period or the delivery of the invoice, whichever happens later. And then once the contractor has to pay its lower tier subs within 14 days of receipt of payment from the from the owner or receipt of the invoice, whichever is later there. And if it's not timely, interest will accrue. And interest will accrue, says 1% per month penalty as interest as a penalty. Under CASPA, payments only entitled to be withheld on account of good faith claims for what's referred to as deficiency items. And that's where work which the owner contractor won't certify as being complete according to the specs. The owner has to provide a written explanation within 14 days after the invoice of any deficiency items. Otherwise, deficiency items are waived. And similarly, the contractor withholding money for deficiency items has to provide that notice to its subcontractor within 14 days or it's waived. In any litigation or arbitration under CASPA, the substantially prevailing party is entitled to recover reasonable attorney's fees and costs, but it's a little bit of a double-edged sword. Substantially prevailing party may also be a party that successfully defends against a CASPA claim. And this is sort of more of a theoretical issue because I'm not aware of any courts allowing defendants to recover for successful defense. I've tried it on a couple occasions and the court just rejected it. So it's possible, but it's probably more likely as a claimant that you'll be able to recover your fees. And as I said, CASPA is in addition to whatever remedies might be available under the terms of your contract may provide for attorney's fees and enhanced interest as well. So you'd look there too. There's a question, what can a construction manager subcontract? The question is what happens in the event of a Chapter 11 bankruptcy. In Pennsylvania, you cannot move forward with the enforcing the lien while there's bankruptcy in place. So you would wait for the bankruptcy to be over before doing that. I could get into that further. I don't. That's sort of the general way of answering that. Now we'll deal with cancellation of projects in New Jersey. And New Jersey, you have, similar to mechanics lien law in Pennsylvania, you have the construction lien law, and that provides any contractor, subcontractor, or supplier provides work, material, or equipment pursuant to a contract shall be entitled to a lien for the value of work or services performed or material or equipment furnished in accordance with the contract and based upon the contract price. And what's significant there is, unlike in Pennsylvania, where liens are more equitable in nature, you don't need to have a contract in writing, an oral contract can give rise to a lien. In New Jersey, it has to be a written contract signed by the party against whom you're asserting your lien claim. So if you're a sub, it has to be authorized in writing by the general contractor. If you're the general contractor, it has to be authorized in writing by the owner, so forth. And you can't lien for unauthorized, unapproved change orders absent something in writing that shows an agreement to pay, not only to pay, but to pay for the labor and materials at the pricing that you're seeking. Could be signed delivery tickets, as a possibility, but there needs to be something in writing signed by the other party. In New Jersey, there is a penalty if you willfully overstate your lien. You may be liable for the other side's attorney's fees. That doesn't exist in Pennsylvania. In Pennsylvania, if you overstate your lien, you just get stricken. So you want to be careful about only liening for items that are authorized in writing in New Jersey. So who can file for a construction lien in New Jersey? Contractors, defined to include architects, engineers, and construction managers with contracts with owners or management associations. Subcontractors, first and second tier, as well as suppliers. And what type of work is eligible? Any activity that improves the real property, including the labor of a paid employee when the lien claimant is a contractor or subcontractor. You can also lien for services, professional services, provided that the parties improve the real property, preparing plans or studies. So licensed architect, engineer, land surveyor, certified landscape architect has lien rights. And you can lien for materials or equipment furnished. Note of caution that New Jersey, there's a distinction in New Jersey between residential and non-residential liens. There's additional steps with regard to a residential lien, which we'll get to momentarily. So filing on a non-residential property in New Jersey, it's a standard form that's set forth in the construction lien law. You just follow the form. We prepare them routinely, and basically you're filling in the blanks on that form. It has to be filed within 90 days of the last date of work. It gets filed with the county clerk. It doesn't actually get filed in the court, and there's no prior notice requirement. I did have a prior blog post, I believe in last year, that there was an extended period of delay during COVID, and as we come back from COVID, where county clerks were kind of inundated with lien filings, and that was leading to some liens, even though they're submitted within 90 days, don't actually get filed till after the 90 days. So it's always our recommendation that you leave yourself plenty of time to ensure that even if it takes a little bit longer to file, it gets filed within that 90-day period. So in the residential context, there's an additional step prior to filing. You have to file what's referred to as a notice of unpaid balance and right to lien, or a NUB. That's in a form that's also required by statute or provided by the statute. And a NUB is essentially you are requesting, you're contending that you have a notice you're providing notice that you've been unpaid balance and contending that you have a right to file a lien. Once that gets filed in the clerk's office, you immediately file an arbitration demand with the AAA, and it's a real fast track arbitration, but the arbitrator decides whether you have a right to file your construction lien claim. And the reason for that is it's additional protection to residential property. Residential liens are disfavored because someone's occupying a residence. So the courts want to be sure, the legislature made sure that if you're going to file a lien, there needs to be an independent third-party arbitrator telling you have the right to do so. A filing of a NUB is also optional on a commercial project, but there's no requirement. You can do that. If you do file on a non-residential or commercial project, the timing requirements remain the same. You have to file your lien within 90 days. Whereas on a residential project, once you get your decision from the arbitrator, you have to file your construction lien claim within 10 days, but no later than 120 days following the last date of work. New Jersey also has a Prompt Pay Act, similar to CASPA. The Prompt Pay Act in New Jersey applies generally to both public and private projects. Right now we're focused on private, but the same will typically apply on public projects. The owner has to pay the prime contractor within 30 days after the date of periodic and final billing. Unless there's a written statement regarding withholding payment within 20 days, there's no real defense to the owner for failure to make payment. So similar to Pennsylvania, we have to provide the deficiency notice. You have to provide the notice of withholding within 20 days of receipt of the application for payment. The contractor then has to pay its subs within 10 days of receipt of payment from the owner, and same down the chain. The first tier sub has 10 days to pay after receipt from the GC. The New Jersey Prompt Pay Act provides for prime rate of interest plus 1% as a penalty for late payments. And similar to Pennsylvania, if you have to commence litigation or arbitration to get paid, the litigation or arbitration has to be conducted within the state of New Jersey, but the prevailing party is awarded costs, reasonable costs and attorney's fees. And once again, this is that same sort of double-edged sword issue that if you successfully defend against Prompt Pay Act claim in New Jersey, you can also try and seek your fees. But similar to Pennsylvania, I'm not aware of any cases where courts actually allowed a defendant to recover its fees. So now we're going to talk a little bit about canceling public projects. And similar hypothetical, ABC Contracting was contracted by State University to provide services on a new dorm building for a public university. ABC's begun its performance. The project's moving along just fine when State University decides to cancel the project. What happens now? Well, unlike on private projects where payment bonds are optional, public projects are secured by payment bonds. And in Pennsylvania, typically you don't have any mechanics lien rights. The language of the mechanics lien law in Pennsylvania is that where the project is for a purely public purpose, you don't have lien rights. Most contracts with public entities are for a purely public purpose. Occasionally, there might be a private project with a public entity, but generally speaking, the overwhelming majority of projects with a public entity are public projects secured by a payment bond, and you won't have lien rights in Pennsylvania. In the federal government context, there's a statute called the Miller Act, which requires that all projects for the federal government have payment bonds to secure payment and performance bonds to secure performance. And the states have generally enacted statutes of their own, informally called Little Miller Act, but more specifically in Pennsylvania, it's the Public Contractors Bond Law of 1967, and in New Jersey, the Public Works Bond Act. New Jersey also has, in certain circumstances, a Trust Fund Act, which provides that if the public owner pays funds to the general contractor, those funds are held in trust for its subcontractors. So the Miller Act, as I mentioned, it applies to federal government contractors, doesn't cover state or local projects. Federal government contracts greater than $100,000 doesn't apply to state and local projects. Second-tier contractors and suppliers have to give a notice of claim within 90 days of the last date of work or last materials furnished. And again, that's so the general contractor can make sure that the claim gets paid prior to a claim being made on the bond. And the a complaint gets filed in federal court if there's no payment made. And that's the federal court for the state and district where the project is located. So if you're in Philadelphia on a project for the United States government, your claim under the Miller Act will get filed in the United States District Court for the Eastern District of Pennsylvania. Pennsylvania has the bond law, which is essentially the state equivalent of the Miller Act. It's required on all public projects where with contracts with the state, the amount of the contract exceeds $5,000. So that's most contracts. And where the value exceeds $10,000 for contracts with state and local or local agencies, counties, school districts, boroughs, townships, and municipal authorities. So how do you assert a claim on the payment bond under the bond law in Pennsylvania? Claims have to be brought within a year, and you can assert a claim once 90 days after the claimant has last performed work. So the higher tier have to make payment within 90 days, and after 90 days, you can assert a claim on the bond. Because the payment bond substitutes for the lien claim in a public setting, the general consensus is that the scope of protection under the bond law is no greater than that of the mechanics lien law. So subcontractors on a public project are typically in the same position with respect to the defaulting contractor as they would be on a private project. So you don't get greater rights under a bond than you would have under the lien law. Pennsylvania has the Prompt Payment Act provisions of the Procurement Code. So this is sort of the another way to get paid outside of the bond scenario. It's essentially the public project equivalent of CASPA. It's limited. There are limited exceptions, but it applies on most public projects in Pennsylvania. Under this statute, it's a similar type of scenario. The owner has to pay the prime contractor within 45 days after receiving its request for payment. And then the prime contractor has to pay within 14 days after it receives payment from the owner. And that continues down the chain. There's a similar ability for an owner to assert deficiencies as 15 days after receiving the pay app to do so. Otherwise, it's deemed waived. And these dates can also be modified by contract, but these are your default 45 days owner to prime, 14 days after receipt of payment, anywhere down the chain. There's interest on late payments, and like CASPA, there's the ability to collect attorney's fees as the prevailing party. It's a little bit different in that you have to show, in addition to the failure to make payment, that the failure to make payment was done in bad faith. And again, it has that prevailing parties language, so that can be a double-edged sword, at least theoretically. New Jersey public projects, there's the Public Works Bond Act requiring a payment bond on all public construction projects in at least 100% of the contract price. There's certain additional requirements where the project's over $850,000 and as well as over $3.5 million. That's generally in terms of who's able to serve as the surety. From a claimant's perspective, that doesn't really matter too much. In order to exercise your rights on a public works bond in New Jersey, lower tier subs have to provide a written notice to the contractor prior to starting work. That's similar to your notice of furnishing on the listed projects in the mechanics lien law in Pennsylvania. But if you don't provide that notice within at the start of your work, it doesn't forfeit your rights under the Bond Act. It just means that you can't assert bond rights until you've provided the notice. So if you're performing work, 6 months goes by, you haven't provided that notice, you're a lower tier sub, you don't have bond rights for that 6-month period. If at 6 months you provide that written notice, then you have bond rights from that point forward. You have to file your, assuming you don't get paid on the bond, you have to file a complaint within 1 year. And like the Pennsylvania bond law, you have, there's 90 days to make payments. So you can't file your bond claim until 90 days have gone by after a demand's made. New Jersey also on public projects, on some public projects, has a statute called the Municipal Mechanics Lien Law, which creates a lien right for contractors, subcontractors, and suppliers when under a contract with a public agency. This is not a lien against public property, it's a lien against the public funds. And public agency in this context means county, city, town, township, public commission, public board, or other municipality. What this doesn't cover is contracts with the state of New Jersey. So if you have your contracts with the state, you don't have any municipal mechanics liens rights. You would have your bond rights, but not rights under this statute. In order to enforce your rights under the New Jersey Municipal Mechanics Lien Law, you have to give notice of furnishing within 20 days from their first day of work. There's a form provided under the Municipal Mechanics Lien Law. And if provided after that 20 days, the lien's available for any work or materials provided after, which is similar to what we went through on the bond law. The lien amount can't exceed the contract price. And there's a timing component here. You have to file your lien no later than 60 days after the project's completed or accepted by resolution of the public agency. Same thing with the enforcement action. So you can file them at the same time, but it has to be done within 60 days after the project as a whole is completed and accepted by the governing body. And you provide this, you give your lien to the officer of the public agency who sort of keeps track of these in what's referred to as the lien book. But once the project's been over for more than 60 days, whatever liens that are filed really become a nullity because you can no longer enforce them in Superior Court. And I mentioned the trust fund statute, and that applies on public projects in New Jersey, including projects with the state. And that really, the funds given from the state to the general contractor constitute a trust fund. And once those are paid, this trust fund remains in place until the general contractor pays its subs. It doesn't include funds that remain with the state or municipal services. So if the state hasn't made payment to the GC yet, there's no trust fund created, and only the first tier subs are eligible to seek funds from the trust account or from the trust amount because the general contractor is only holding money for its direct subs. Now we're going to shift into the third item, cancellation for material suppliers. So here, let's change the hypothetical just a little bit. ABC is contracted by big bucks to provide steel for the construction of a new office building. ABC has begun to deliver the steel. The project's progressing. Big bucks notifies them the owner has canceled the project. So what are your rights here? You've started delivering steel. It hasn't entirely been delivered. What are your rights? There's a few different rights. Might have lien rights if it's not a public project, bond rights if there's a bond in place, or if it's a private project, or if it's a public project, rather, optional in a private project. There might be remedies under the Uniform Commercial Code, which covers the sale of goods. We're talking about steel that's being fabricated. It's a movable good. So you might have rights under the Uniform Commercial Code. You'd also have your contract remedies. Same thing with CASPA, with New Jersey Prompt Pay Act and the Pennsylvania Procurement Code. So regarding mechanics lien rights, material suppliers are eligible for liens and payment bond claims in both the Pennsylvania and New Jersey. In most instances, Pennsylvania, the lien law requires that the materials be incorporated into the project. So you'd be looking for some sort of physical joinder to the improvement. If your materials are sitting on a truck or in a warehouse, generally you don't have lien rights. If they're delivered, you may or may not have lien rights. And we'll get to that in just a moment. New Jersey courts have been a little bit more liberal with this and have allowed lien rights in certain circumstances where the products were delivered but not actually incorporated. So in Pennsylvania, bond rights somewhat similar. arise at the incorporation of the material. This is on a public project. Obviously, on a private project, you look to the terms of the bond. And the reason why it's this way on the public project is because of the bond laws intended to provide no greater rights than the lien law. So you still look to joinder of the goods to the project, and New Jersey, you look to delivery. So in Pennsylvania, how do you get paid? If you don't know if the materials were used, say you're delivering steel, you drop it off, you never hear anything further, and the project gets canceled. Materials for use in or upon an improvement placed on or near the property or delivered to the owner pursuant to a contract shall be presumed to have been used therein in the absence of proof to the contrary. So there's a presumption here. If you're delivering materials and you leave them at the project site and they're accepted, the presumption is that they are part of the improvement. It would then be incumbent upon the owner to prove that they weren't used in the construction and the improvement of the property. If you, in addition to mechanics lien claims and payment bond claims, both Pennsylvania and New Jersey statutes extend prompt payment rights to suppliers. And I mentioned regarding the UCC, the Uniform Commercial Code. Article 2 of the UCC governs the sale of goods, speaks in terms of sellers and buyers. Generally, if you're a higher tier contractor, you're buying the material. You're the lower tier contractor that's fabricating the material. You're selling it to the buyer. Goods are all things, including specially manufactured goods, which are movable at the time of identification of the contract, other than the money which to be paid. So if you're talking about structural steel, you're talking about sheet metal, items that are fabricated for incorporation into the project, and you're shipping them out on a truck, those are generally would be considered goods. But in many circumstances, your contract may not be solely for goods. Certainly, if you're a steel fabricator, that's probably goods. That's goods. Your only obligation is to fabricate the steel. You're just talking about goods. But if you're also tasked with erecting the steel, well, then you have both goods and services. So what happens there? It's a little bit amorphous. Courts will tend to use what's called the predominant purpose test to determine whether it's predominantly a sale of goods. If it's predominantly the sale of goods, you'd have rights under the UCC. If it's predominantly the sale of services, you don't. You would just have your contract rights and your bond and lien law rights. There's no real one set test to determine that. Sometimes courts will look to, if there's a breakdown of the price, if most of the price is allocated towards the fabrication as opposed to the erection, that would be goods, but it's not always clear cut. So who cares, right? If you don't have UCC rights, what difference does it make? And what remedies do you have under the UCC? The remedies really vary depending on how the buyer breached the contract. If the buyer repudiates before the manufacture is complete, or the buyer accepts the goods but then doesn't pay. And I prefer to focus on the former since we're talking about the project getting canceled. There's also a duty under the UCC to mitigate. That's true of all contracts, that you have to mitigate your damages to the extent it's reasonable. Under the UCC, the buyer can limit its damages by showing an action the seller could have taken to reduce its damages and didn't take that action. For instance, if you fabricate steel, you can't get 100 cents on the dollar if the buyer can show that you could have sold the steel elsewhere at the same price. So in the circumstance where the buyer cancels the delivery before the manufacture is complete, you need to stop. The first step would be either you can do one of three things generally. You can either stop production, finished production, and in some circumstance, if you're the fabricator, you can recover the contract price. It's not always available, as we'll get to momentarily. So if the seller stops the production, the seller can seek lost profits, incidental damages, and costs reasonably incurred. And incidental damages are typically your storage costs, your shipping costs, resale costs, sort of your transactional costs that arise. Where the seller completes production, though, the seller is able to seek the difference between the contract price and the price for which the goods were resold to a third party. That's called the cover price less the contract price. And again, any incidental damages, storage, shipping, and resale costs. And lastly, well, what happens if the seller can't resell the goods? For instance, you're talking specially manufactured goods. They're ornamental steel that's particular to a specific project. And it's impossible to resell. All you can get is scrap value. Then you might be entitled to get the full contract price less whatever the salvage value is. But that's only available in the context where resale isn't possible. And that shifts us into specially fabricated materials, which we just discussed just briefly there. So let's change up the hypothetical again. ABC's contracted by big bucks to provide specially fabricated steel for the construction of the new building. The project's canceled after the steel was fabricated, but before it was delivered. What can you do here? It gets a little bit more complicated. In Pennsylvania, there's no mechanics lien rights if the project's not furnished, or if the material is not furnished to the project site. But our recommendation in this context is to nevertheless attempt to assert your lien rights, and to do so by offering to furnish the materials. As I mentioned, when you're asserting a mechanics lien claim in Pennsylvania as a subcontractor, which you'd be as a especially as a manufacturer of specially fabricated material, you would be a subcontractor. So you have to send that notice to the owner of your intention to file a lien. So we typically will recommend at the end of that letter to include some language. Additionally, ABC is in the possession of certain structural steel that is specially fabricated for the project and is ready, willing, and able to deliver to the project. Please contact me within the next 30 days to arrange for delivery or to advise that you're refusing delivery. If I don't hear from you within that time period, ABC will deem such lack of communication to be a refusal of delivery and may take appropriate action. So you're putting the owner on notice that, hey, I have this material here. I'm ready to deliver it. Let's make arrangements to do so. In Pennsylvania, that should be sent alongside the notice of intent to lien, and actually as part of the notice of intent to lien. In New Jersey doesn't require notice, but if this issue arises, you can still send the same letter and as early as practicable, since you only have 90 days to file a construction lien claim. But you may be asking, well, will this language actually work? And to be honest, I don't know. There's a lack of case law on the issue generally. The only case I've ever come across in Pennsylvania on specially fabricated goods held that you can't lien if the material is sitting in a warehouse, not actually delivered to the project site. But if you raise this issue that you're ready, willing, and able to deliver the material, and the owner says, I don't want it, well, the owner's preventing you from delivering it. And because a lien it's a statutory remedy, but it's equitable in nature, as the supplier, you can then make an equitable claim that the owner shouldn't be able to evade its payment obligations by refusing to accept delivery. Now, I know we focused on Pennsylvania and New Jersey, but there are actually a handful of states that specifically provide for lien rights for specially manufactured goods, regardless of whether they're incorporated into the project, in particular, Florida, Nebraska, and Texas. So if you're performing work in those states and project gets canceled, well, you're in luck in that you can maintain your lien rights regardless of whether the materials were actually incorporated. And we did have a question in advance of the webinar. What happens if the project's not canceled, but just suspended for an extended duration? And I believe that arose in a scenario where lead paint was found on the project and the owner has been not moving forward with any work while that's being remediated. The most important thing to do is look to your contract. Is there a right to, many contracts, standard form construction contracts will provide a right to terminate if there's a suspension for more than a particular number of days. Maybe that contract will set forth what your entitlement is to additional compensation for those delays. You should always be mindful of what notice is required. Typically, contracts will have notice requirements. Notice has to be provided in writing. It may need to be provided to a particular individual. So you want to be in constant contact with the owner and in that comports with the notice requirements in the contract. And you want to pay attention to the dispute resolution procedures to the extent that there becomes a disagreement as to what you are or not entitled to do. But absent that, it's really important to have an open communication with the owner regarding the impact of the suspension. If you have to return a year from now, there may be additional costs of demobilization and remobilization. Maybe it makes sense to come to an agreement with the owner to demobilize so you're not sitting out there on site incurring general conditions costs every day. So there are a lot of variables there, but really looking to the contract and communication is key there. So generally the conclusions of what we went over: private contracts, liens can be filed against improvements by contractors, subcontractors, material suppliers, gives you security interest in the real property. In addition, Pennsylvania and New Jersey have statutes allowing an action seeking outstanding fees plus interest. That's referring to CASPA and the Prompt Pay Act provisions, the Procurement Code in Pennsylvania and the Prompt Payment Statute in New Jersey. Public contracts, purely public purpose in Pennsylvania, and contractors, subcontractors, and suppliers can seek compensation under a payment bond. The Miller Act on federal projects, Little Miller Act, the Public Works Contractors Bond Law in Pennsylvania, the Public Contractors Act in New Jersey. And regarding material suppliers, materials need to be incorporated into the project for lien rights and bond rights to arise in Pennsylvania. New Jersey, lien rights will arise upon furnishing of materials. Specially fabricated materials that aren't incorporated prior to cancellation don't receive special protection in Pennsylvania or New Jersey. But if you're in that scenario, you want to try and send that letter to shift an argument back to the owner that you're ready, willing, and able to deliver the materials and they're refusing. And here we have my contact information. Once again, my name is Matt Erlanger. I'm very, very accessible. You can reach out to me via email, or that's my direct dial here at the office. So if there are any questions, you can reach me there. And if anyone has any additional questions that they want to type into the question and answer box, you can do so. Otherwise, that concludes the presentation. And there was one question here. Can you send a copy of the slideshow for reference? I believe that we can arrange that. And there was that earlier question about the bankruptcy. We do have bankruptcy lawyers at our firm that can further assist you with specific bankruptcy related questions. As I mentioned, I'm doing construction litigation primarily, but we do have bankruptcy counsel, specifically Bill Firth in our Delaware office does bankruptcy, and some others as well. So if nobody has anything further, I thank you all for coming, and feel free to reach out to me with any questions.